LA's conduct within tribunals case law. So JFR on the application of v London Borough of Croydon and the Special Educational Needs and Disability Tribunal 2006. In a said tribunal appeal, the local authority is required to assist the tribunal by placing all relevant information before it, including material that may not support its own case. So basically, the local authority are not allowed to withhold, not include, or hide any relevant information that could help the tribunal, even if it doesn't support what the local authority want to do. That's what this is saying. LM versus Birmingham City Council Sen 2026 UKU. This case supports the argument that the local authority should ensure the working document includes sections A and E, as well as the sections under appeal. The upper tribunal noted that these sections provide an important opportunity to capture young persons' motivations and potential outcomes such as skills development and employment. Without them, there's a real risk that the tribunal may not give sufficient consideration to the young person's aspirations and the outcomes, and that their supporters consider appropriate, as it may lack the necessary context for its decision. This is interesting because right now, with the limited size of working documents, what we're finding is that it's impossible to include all sections, especially when we've got a super complex child who has a lot of needs and needs a lot of provision. So we're actually having to limit other sections to make sure that it's small enough for to be accepted by a tribunal, because they don't want the document to be longer than 25 pages. But I suspect that is all to do with pressure from the local authorities and governments on trying to find ways to limit parents' cases, to be quite honest with you. London Borough of Edinburgh versus AP and SP 2024. Local authorities, LAs, have a duty to assist their Sen Tribunal in resolving appeals fairly and justly. This includes minimising delay, cooperating fully, and being transparent about all relevant information. LAs must be properly prepared, which may involve raising issues or alternative options during the course of the appeal, rather than attempting to introduce new alternatives after the tribunal has made its decision in order to argue it should have received a different outcome. So basically what this is saying is that the local authority should be doing their best to assist the tribunal, be prepared, raising issues they've got, offering alternatives that may help come to decisions, and they shouldn't be obstructive, which is what they are quite a lot of the time. PS versus LB of Wandsworth Sen 2025. This case highlights that where a parent's conditional right to have a Section 38(3) Children and Families Act school named is displaced on appeal under Section 39(4) of the Children's and Families Act 2014, and neither party invites the Sen Tribunal to consider alternative school, the tribunal will instead name a suitable type of placement. However, this does not permit a local authority to subsequently remove a child from the role of special school without consulting the parents. It also emphasises that if parents or young people are concerned that their preferred setting may not be named, or strongly oppose the local authority's proposed placement, they could put forward an alternative option for the Sen Tribunal to consider. The Sen Tribunal is entitled to make decisions on that basis that the local authority will comply its legal duties, and caution shall be exercised when relying on AI-generated content, as it may not always be accurate or reliable. So this is saying about if both schools are deemed by the tribunal to not be suitable, that they do have that chance of naming placement, and if it does come down to that point, there is also that chance where an alternative placement can be proposed by parents if they are concerned about the local authorities or strongly disagree that the local authority will propose a suitable placement.